Equity Committee meeting. Today is Tuesday, December the 5th. Council Clerk, will you please call the roll?
Calling the roll, Ms. Brown.
Here.
Mr. Gallagher.
Here.
Mr. Jones. Mr. Jones is absent at the moment. Mr. Miller.
Here.
Ms. Conwell. Ms. Conwell is absent at the moment. Let the record reflect Ms. Baker and Mr. Brady are also here. We have a quorum.
Thank you. And Councilwoman Conwell and Councilman Jones did indicate they would be a little late this morning, so I do anticipate their arrival. Council Clerk, do we have any public comment related to the agenda?
No, no one has signed in.
All right. I will move on to item number 4 for approval of the minutes from the November 21st meeting. I'll make a motion to approve. Do I have a second?
Second.
All right. If there are no questions, comments, or concerns regarding the minutes, all in favor, please say aye. Aye. All right. Thank you. And we will now move on to matters referred to the committee. If you'll read the first item into the record, please.
Resolution number 2017-0229, confirming the county executive's appointment of Moselle T. Jackson to serve on the Cuyahoga County Board of Developmental Disabilities for the term 1/25/2018 to 1/24/2022.
Thank you very much. And it looks like we have a new gentleman here to speak to this item in the absence of our Mayor-elect Cross. We have Mr. Michael Hauser. Would you please give us a little bit of background regarding this appointment?
Definitely. Good morning, Councilwoman, Council. Moselle Jackson is looking for the appointment for the Board of Developmental Disabilities. Cuyahoga County Board offers a wide range of services, everything from in-home, early innovation programs for very young children and their family, and leisurely programs for seniors and family, including resources from supporting living, vocational training, community employment, and crisis intervention. The county appoints 5 of the 7-person board. The other 2 members are appointed by the senior probate judge for the county. If confirmed, Moselle Jackson will replace Diane Roman Fusco. Ms. Fusco's terms out in January and cannot be reappointed. The county executive is recommending the appointment of Ms. Jackson based on her qualifications and accomplishments as outlined in her bio and appointment letter. Thank you.
Thank you very much. At this time, I'll ask Ms. Jackson to please step forward, state your name for the record, give us a little bit of background and your interest in serving on this board. Good morning. If you'll hit the, you got it.
Good morning.
There you go.
Moselle T. Jackson. I am interested in serving on the board. I have twins, a boy and a girl, 20 years of age. Our son has cerebral palsy, and I'm interested, obviously, as a consumer. There's obviously been some changes with everything going on with the County Board of Developmental Disabilities, and I would like to be a part of that change and look to be an advocate for the community. I also feel, as with my background on the business side, both financial, business, change management, I think I can be an asset to the board.
Thank you very much. Having been a parent of a person with developmental disabilities, is there something personal that you can share as it relates to an initiative or program or service that you would like to see this board take steps in doing?
Sure. It's really on the transition side that we see. Jared is allowed to be in the school district till the age of 22. There's obviously many different avenues that a young adult can go depending on their individual needs. And I think really understanding and educating the community about what those steps are and how the board can assist and support not only the individual but the family, I think would be very important.
Thank you very much. I'll open it up to the committee if you have any questions, comments, or concerns as it relates to Ms. Jackson. Well, there being none, oh yes, Councilwoman Conwell.
But not really one. I came in on the twins part.
Okay.
How do you do it?
My husband's great, so we are great partners. So we do it together, and the kids are fantastic. So it works.
Wonderful. If there are no additional questions, comments, or concerns, I want to thank you so much for coming in today. There was a precedent set by my predecessor, Councilwoman Conwell, to have people that are interested in serving on these boards come before this this committee so that we can, in fact, put a face with a name and understand your desires from your own mouth on what it is that you like to do and how you like to serve on these boards. So we thank you for your time and your willingness to serve in this capacity. I think at this particular point, if there are no objections, I'll make a motion to move. What I need to know is if there's a meeting coming up, and I think I see, is there a meeting coming up that we would need to move on second reading suspension?
Not until January.
Thank you.
Thank you. Kelly Petty, Superintendent of the Cuyahoga County Board of Developmental Disabilities. Our organizational meeting is January 25th, 2018, so that would be Ms. Jackson's first meeting.
I think that would afford us a full 3 readings. So I thank you for and the administration for their time and giving us an opportunity to do the full 3 readings. So I will move this to the full body of the council for 3 readings. Do I have a second?
Second.
All right, it's been moved and seconded. All in favor, please say aye. Aye. All right, thank you very much.
Thank you very much.
All right, if you will read the next item into the record, please. Council Clerk?
Ordinance number 02017-007, amending section 302.01 of the Cuyahoga County Code and amending the Cuyahoga County Human Resources Personnel Policies and Procedures Manual to repeal paragraph 1.03, disclaimer, reservation of rights.
Thank you very much. This item was introduced by the council. I am looking for Mr. Trevor McAleer. He is a representative on the Audit Committee, and he will give us a timeline as well as the background on how we have come to the place to introduce this item.
Good morning. Excuse me, Trevor McAleer, County Council staff. I'll be presenting a timeline that you should have in front of you. I'm up here today mainly as the council representation on the Audit Committee and also discuss kind of the timeline of events of why this legislation was introduced on Tuesday. So we're going to go starting at the beginning point in time where the Internal Audit Department, as part of the risk assessment, decided to review and conduct a payroll audit that was originally planned to run from January 1st, 2014 to December 31st, 2014. That was the initial time period that, at that point, Val Harry and her staff determined to review. The internal audit staff started to do their internal review of documents and decided to extend the date beyond December 31st, 2014 after discovering some high-risk findings. So in their initial review of the data, they decided to just extend the time period. That isn't all that uncommon when they're doing internal audits, but they decided to continue to go beyond December 31st, 2014. This work really began towards the end of 2015 as the internal audit staff was finalizing other audits that they were working on and increased their work volume sometime in the summer of 2016. And that's really when the bulk of the audit began. So just to put everything in context, we're talking about the summer of 2016 when the audit staff started thoroughly doing their audit. Draft audit findings and recommendations were provided to HR, the administration's HR department, and these are the initial drafts sometime in December of 2016, so about this time last year. This is pretty common in terms of the internal audit department. When they find their initial findings, they will go to whatever department that they are auditing and sit down with the administrators, managers, supervisors of the departments and discuss what they're finding in terms of their audit. Then in April of 2017, after receiving feedback and continuing their audit, Corey Swaysgood, who is the director of internal audit, met with the HR payroll team, including Chief Talent Officer Douglas Dykes, the executive, and others, to discuss what he is finding, which is typical for other audits that he conducts. The first draft of the audit findings was provided to council staff in May of 2017. So typical, just how Corey and Val Harry, who was here before him, would conduct their audits. They provide council staff with a first draft of their audit. Now, as you can imagine, that first draft will change drastically as they finalize the draft, but that is the first time that council staff saw the first audit findings in May of 2017. We met with Corey on June 2nd to go over the findings, as we typically do for each audit. He'll come up and just present, here's what I found, here are the management responses, this is my initial draft, do you have any feedback as council staff, anywhere we should look at, any input, etc. So we had that discussion on June 2nd. A couple days later, Director Swaysgood met with the law department to discuss his draft audit findings. That's typical too, and when they conduct audits, again, he's doing his necessary research and work and discussing all the audit findings with the appropriate administration and law department staff. At that point, the plan was to originally release his audit on June 30th, 2017. And because of the discussions that he was having with the administration, council staff, et cetera, the revised date to release the audit, the payroll audit, became July 30th, 2017. At that point, July 30th passed. He was still working on his audit, continuing to revise his audit findings, and the administration was also continuing to provide feedback. Director Swaysgood asked if he could meet again with council staff to go over his revised version of the draft audit, which we met with Corey on August 14th. So we're a couple weeks past the original or the revised date of July 30th to publicly issue the payroll audit. We had an upcoming audit committee on August 25th where the draft payroll audit was on the agenda for discussion. That is where the department and the Chief Talent Officer, Douglas Dykes, came in and acknowledged the auditor's findings and provided great responses of what he's already done as the Chief Talent Officer and what he plans on doing over the next couple months to correct the audit findings. I think the biggest thing that he presented in the audit committee was that in the next couple months, we'll be submitting a revised HR policy manual to correct some of the findings to County Council in the next couple months. And he provided a timeline, probably no later than January of 2018. So we're still within that window. So at that point, it was, we were under the impression that the corrective action for the findings in this internal audit was that we would be getting a revised HR policy and procedures manual to address the concerns that were in the audit. After going and providing final feedback from the administration and the law department, the audit committee on September 28th agreed to release the final version of the payroll audit, which took place on September 29th. So the audit was officially released and became public on September 29th. I don't know exactly how many versions it went through, but it was at least close to probably 10 versions, which is typical. Then on Thursday, November 9th, as you all know now, a story was published on Cleveland.com about the payroll audit findings, which is also typical. Sometimes Cleveland.com will write a story on previous audits that the internal audit has conducted. Then on November 14th, a couple days later after the story, Cleveland.com reporter Karen Farkas made a public records request to the internal audit department, which went to Corey Swaysgood as the director for backup information regarding the payroll audit. A couple days later, on Friday, November 17th, the administration went to Cleveland.com's editorial board, now disputing the findings in the payroll audit, citing that section 1.03 of the HR manual was a justification of why they were able to basically pay the extra compensation that was discussed in the payroll audit, and really the point of the Cleveland.com story that was originally submitted on November 9th. That was the first time that council staff and county council members learned that that particular section, which is in front of you today in legislation form, was being used to being used as the justification to pay the individuals the additional pay. So that was on November 17th. And that was really the stepping stone of why council walked on the legislation here in at the last Tuesday council meeting, because that was not the intent of that section of the HR Policy and Procedures Manual, which Mike King will come up here shortly to discuss a little further about that. On Friday, November 17th, Director Swaysgood did respond to Karen Farkas's request and submitted a host of information that she asked for, which there's a lot of backup documentation that you don't see that helps create the final version of the audit. As I previously mentioned, on Tuesday, November 28th, County Council walked on the legislation repealing that section 1.03 of the HR manual, which again was the section cited by the administration at the November 17th editorial board meeting, which was approximately 11 days after we learned about that. That was the section that was being used as justification to do that. Actually the following day, the county prosecutor issued an opinion to the audit committee stating that the administration violated the county charter and the county code. And then a couple days later, Friday, December 1st, as many of you have read, there was an editorial on Cleveland.com saying the administration must fix the payroll issue. And on the same day, the administration apologized to Cleveland.com, but still acknowledged they had the authority under the section that we're discussing today to continue to do what they had to do related to the extra pay. And then that brings us here today of why the legislation is in front of this committee to further discuss with staff and the council members about this particular section of the HR Policies and Procedures Manual.
Thank you. If there are no questions from the committee, then I'll ask Mike King to come up and give us an overview of the legislation. All right, thank you.
Thank you, Madam Chair. As Mr. McAleer noted, at the November 17th meeting with the Cleveland.com editorial board, administration officials stated that Section 1.03 of the policy manual justified the additional compensation paid to overtime exempt employees. Again, this was the first time council had become aware that the administration was using this rationale to dispute the auditor's findings. One thing, just for the record, we are not aware of any instances at this time where county employees were compensated for time not actually worked. However, in response to the administration's claims at that November 17th meeting, multiple members of council requested or verbalized their disagreement with the administration's interpretation of Section 1.03 of the policy manual and requested that legislation be prepared to amend the policy manual to remove the provision in question. As you're aware, Section 1.03 of the policy manual has historically provided the administration flexibility to manage workforce when extraordinary or extenuating circumstances arise, but this provision was not intended to allow for the implementation of ongoing practices that materially conflict or deviate from the county's codified HR policies, including the policy manual. So in a nutshell, what this legislation or the ordinance does is two things. First, it simply repeals Section 1.03 of the HR policy manual, and you should have a red line so you can see what exactly is being deleted. And two, it clarifies that the policy manual shall be followed not only by county employees, but also by the Department of Human Resources and charter appointing authorities, so that it's clear that these are the policies binding on the administration as well as employees approved by council. So if there are any questions, I'm happy to entertain those.
Could you repeat the second one?
Sure.
Chair to Mike.
Yeah, so
you said the ordinance did two things, repeal section 103.
Yes, so part two, it's actually on the second page of the ordinance. It amends section 302.01 of the Cuyahoga County Code. And in there, you'll see that it clarifies that the policy manual shall be followed by not only county employees under the authority of council and the executive, but also the Department of Human Resources and charter appointing authorities.
Okay. Thank you.
Are there any further questions, comments, or concerns? All right, I will open it up to the administration. If there's anything that you would like to state with regards to this matter, please step forward, state your name for the record.
Good morning, Ed Morales, Director of Employee and Labor Relations, Department of Human Resources. I would first like to make a few clarifications and offer a little bit of history with regard to the Policies and Procedures Manual and the charter requirement that human resources systems and policies be adopted through ordinance. And really, I think the goal of identifying steps that need to be taken to improve the existing ordinances and to make sure that we're complying with the actual intent of the charter. I was here in 2011, acting as the law director at the time that the original ordinance was adopting the Human Resources Policies and Procedures Manual was put into place. I don't believe that the adoption of that manual was necessarily an initiative of the administration. I think all parties, council and the administration, desired to ensure, as we began to comply with the dictates of the charter, that we had met all of the obligations of the charter, including that section in 9.01 that speaks to adoption of systems and policies through ordinance. I don't believe that the adoption of the Human Resources Policies and Procedures Manual, although adopted by ordinance, was intended to make the Human Resources Policies and Procedures Manual, or everything in it, black letter law. If that was the intent, I think we ought to rethink our approach. I think it is important that we do obviously comply. We must comply with the charter. I think that section of the charter was designed for the purpose of allowing and authorizing, and indeed requiring, Cuyahoga County to exercise its home rule authority for the purpose of moving away from Chapter 124 of the Ohio Revised Code that provides civil service rules and regulations for statutory counties. And I think that the county did that, and I think council did that through the adoption of Title III employment practices. I don't think that council did it through the adoption of that specific section of the title that adopts the handbook. A handbook should be a document that is easy to read and understand for the majority of employees, and should be written in an easily understood manner for the average employee. And we have many different types of employees, from executive employees to our blue-collar employees who are staffing a number of functions. The handbook needs to be understood by all and should be written in that way. The charter section requiring an ordinance should be something else. Should be set of laws, and I think we have those laws that are aimed at exercising the home rule authority of the county. We've done that through adoption of specific ordinances that are codified in Title III, and we've done that in other respects through reference or adoption, incorporation of Chapter 124, to the extent that Chapter 124 hasn't been repealed or superseded by any specific ordinance. So the idea that the manual itself is intended to be black letter law, providing a set of enforceable entitlements that could be enforced through an action in common pleas court, is not something I think was intended at the time that the handbook was written or approved by council. I think if you look at the intent of that ordinance, really the intent is there shall be a handbook, and that's the policy, that's the system that the charter would speak to. With regard to everything in the handbook constituting black letter law, I think there's a lot of room for disagreement on that, and I don't think that is at all clear. Now, Section 1.03 is a typical provision in an employee handbook that notifies employees that nothing in the handbook constitutes a contract. If we say in section 1.3 that the handbook doesn't constitute a contract, how can we be saying at the same time, however, not a contract, but a set of enforceable rights because it's all ordinance? It's all black letter law. That doesn't make sense. 1.03 clearly is a disclaimer that indicates that, hey, these rules in the manual are guidelines. Now, having said that, I agree. I've had conversations with Mr. King. I agree that the proper implementation of section 1.03 is on an ad hoc basis to meet critical operational needs. And I think that's the intent of section 1.03. It's not intended to be a mechanism to override on an ongoing basis specific policies in the policy manual. And no one from the administration, to my knowledge, has taken the view that it is. I was also present at the time that this was discussed with the editorial board, and the administration did not take the position that section 1.03 allows it at all times, under every circumstance, to just create a blanket new policy. That is not correct. What was being reacted to was the notion, not from the internal auditor necessarily, but from the other previous story that the Cleveland.com had written, that what was done was illegal. So to say that 1.03 was being used as a justification of everything that was paid is incorrect. What 1.03, the reference to 1.03 was to show that, hey, wait a second, let's take a step back from the assertion that everything that was done was illegal. It wasn't illegal. First of all, the policy manual isn't black letter law, it's a set of guidelines. Second of all, 1.03 provides, under some circumstances, the ability to make a decision that is different based on operational needs from the policy as written. Right? I'd like to discuss that a little bit more. This practice of paying exempt employees additional compensation, although apparently not discussed with counsel, which is, I think, problematic. I think there's a communication failure in that respect. This practice of paying of exempt employees is one that goes back many years. So at the time that council approved the manual, the language that existed in the manual was identical to what had been implemented in the years preceding the adoption of the manual, both in terms of policy 6, or chapter 6, that deals with wage and hours of work, and also 1.03. It had been administered for several years preceding the adoption of the charter and preceding the adoption of the manual by council. It had been administered in a way in which the Director of Human Resources had the authority, under specific circumstances, to permit the payment of additional compensation to exempt employees. So we've researched that, and we know that that's the case. So the first documentation that I've seen regarding after the new government came into place regarding payment of exemptive employees occurred very shortly thereafter in 2011. So this is not something that just started in 2014 at the end of the Fitzgerald administration. Indeed, this is something that existed right from the get-go in 2011. Now, I wasn't aware of that, but I've become aware that this has been the way the manual has been implemented throughout the years that the new government has been in place. and it has mirrored the practice that existed prior to the new government with the exact same language in the policy manual. The exact same language in Section 6, the exact same language in Section 1.03. And so, just as an explanation, as a history of that language. But there is no disagreement that Section 1.03 does not permit the wholesale discard of a policy in the Policies and Procedures Manual. It does permit some discretion under certain circumstances to, as in this case, provide payment to exempt employees for additional hours that they worked. But the other thing is, it is not the only section that was discussed with the plain dealer. There is other language in the policy manual that arguably provides justification for whatever decision was made by the various administration officials throughout the years since the new government was formed and since the policy manual was adopted by council originally. Section 6.05 was also discussed, and yeah, I think there's an argument about we could argue about the merits of the argument, but I think it should be analyzed. I don't know that it's been sufficiently considered by anyone, but I've pointed out that Section 6.05 provides authority for the administration to set schedules and hours of work based on operational needs. It speaks to the normal work week being a 40-hour week, and by the way, it clearly applies to both exempt and non-exempt employees, and also says that the normal work week can be extended based on operational needs. Now, these employees were all paid at the, well, I should say, with the exception of some, the vast majority, well over 95% of all the hours that were examined by the internal auditor over this 3-year period, 14, 15, and 16, were paid at straight rate. So another thing that's been an issue, at least a point of concern for me personally, as an attorney, as a labor attorney, is the mischaracterization of this issue as an overtime issue. This is not an overtime issue. Overtime is defined in federal and state law and in our Policies and Procedures Manual as payment of time and 1/2. Very few of these employees were paid time and 1/2. Now, there are some, a small percentage of the employees and of these hours that were paid at time and 1/2, and I think that merits further analysis and research as to why that happened. I know that some of them, the employees, were paid time and 1/2 because they worked on Christmas Day. Some of the employees were paid time and 1/2 because they worked on other holidays. I don't know about the full number of hours paid at time and 1/2, but I will say it is a small percentage of hours. Paying those exempt employees time and 1/2 for working on Christmas is the type of deviation from the strict letter of Section 6, Section 6, that I think is permissible through operation of Section 1.03. And that has been, because there's nothing in the manual that says, if a exempt supervisor is staffing the 696 kids hotline on Christmas, that they would be paid time and 1/2. There's nothing in the manual that says that, admittedly. But Section 1.03 has been used to supply authorization for a decision to do that. Now, there is some opinion that if something is not explicitly stated in the manual or explicitly stated in another ordinance, that it is illegal, and I strongly disagree with that assertion. I think it's a complete misreading of the charter. Section 2.03 of the charter provides that the county executive has the administrative authority of the county government. He is responsible for making administrative decisions. I think the decision to pay some employees time and a half on holidays like Christmas or New Year's is a proper exercise of that authority. And it does not require that council adopt an ordinance covering every aspect of human resources management. Nothing in the charter is intended to require that. And if it did, it would be counter to the other provisions of the charter, including the preamble, which specifically says that the charter is being adopted so that there would be a division between administrative and legislative authority. And then the provisions of Section 2.03 and the various other provisions of the charter that incorporate general law and grant not just to the county executive, but to the other office holders.
Well, Mr. Morales, I'm gonna stop you there. I thank you for what you've shared with us, and I'm gonna do that respectfully because I think you've said a lot. And I know that there may be some questions, and with respect to people's time as well as this committee, I want to afford them that opportunity. I also would like the record to reflect that Mr. Morales, while he is an attorney, he is not speaking on behalf of the law department, but the HR department. Is that safe?
That's correct.
Okay, and so that if there are any questions as it relates to the laws, you cited many ordinances and references to different sections of our charter and bylaws and policies, that those are some things that we will most definitely have continuing conversations with the representatives of the law department.
Thank you.
So I am going to open up the floor to our committee if there are any questions, comments, or concerns as it relates to what has been said and what we have introduced with regards to this matter. And if there are none, then at this point, what I would like to respectfully request of the administration is to present us with something in writing as it relates to how you would like to propose a solution to this problem. We would need that by Tuesday of next week so that we can have something to review and have further discussion and productive dialogue as it relates to this matter.
Very good. Thank you very much.
You're very welcome. Is there any questions, comments, or concerns? All right, thank you very much, and thank you for sharing your position as it relates to this. Madam Clerk, I don't think
Madam Chair,
Yes, Councilman Miller.
I'd like to ask one question of Mr. Morales, if I might.
You might. Go ahead.
Madam Chair, Mr. Morales, you've raised some very, very fundamental questions regarding the relationship between the council, the executive, and the charter. And we currently have in place a structure where we have the charter, we have the ordinances, we also have the board that reviews policies that don't need to be an ordinance, and generally policies that don't need to be an ordinance. They need to have some foundation behind them in ordinance. And what I heard you saying, and correct me if I'm wrong, but it sounds to me like you're saying that the administration can conduct personnel activities in ways that have no general ordinance authority behind them at all. You know, my viewpoint would be that that no, it probably isn't possible to specify every possible situation, but it seems to me that based on the charter language about the council adopting human resources policy by ordinance, that there should be some general ordinance authority foundation by which the administration then uses its executive authority of interpretation and application to individual circumstances. But you don't seem to be saying that. So I'd be interested in your comment on that.
Yeah, I'm not sure I'm saying exactly what you have presented. What I'm saying is that the charter itself, in addition to the various ordinances that exist, provide authority for the actions that have been taken to date. That in addition to a local ordinance, it is also important to understand the charter's incorporation of general law. And unless there is an ordinance that specifically supersedes those provisions of general law, the executive isn't limited from making decisions that affect the administration of human resources. Let me be specific: compensation decisions, which I think are the ones at issue. In various sections of the charter, there are references to general law incorporating the authority of various officers of the county, including the county executive, to exercise authority that's provided under general law. And one in particular that's very important to note is section 325.17, which provides, Ohio Revised Code 325.17, which provides the authority for officers of the county to set compensation. There's nothing in the charter incorporates that section of general law by reference in several sections, notably in Article 5, in section 2.03, in Article 5, in the discussion of the powers of the various officers of the county, and in Article 4, dealing with the county prosecutor. So there are various references to the incorporation of general law. Now, I'm in complete agreement, and I hope I didn't say this in a way that was not that could be misunderstood. The complete agreement, I think, the administration is that the charter calls for a set of ordinances, right? Ordinances to be adopted on human resources systems and policies. And I think that the county has complied with that charter requirement in Title III of the county code. Note that Title III explicitly incorporates Chapter 124 of the revised code to the extent that has not been, those sections have not been superseded by a code provision. And the charter then incorporates the other provisions of general law that are applicable to this situation. So there must be legal authority, Councilman Miller, and that authority, if it has not been undone through an action of council, through an exercise of the county's home rule authority, to the extent that those provisions have not been changed through an exercise of the county's home rule authority, the executive and the other officers of the county are able to act. Now, that doesn't in any way limit the ability of council to take an action, right? Which is your legislative prerogative. And if that occurs, then that becomes the source of future rights.
Madam Chair, to Mr. Morales, I'm going to respond by saying what I've often said before, which is not only am I not a constitutional attorney, I'm not even an attorney, but I do think that that this situation raises some very broad questions about how the council, the executive, and the PRC interact with each other when it comes to setting and implementing personnel policy, and I think that people who I think we're all going to need to deal with these issues, particularly those that have the legal background to do so. Thank you.
Thank you, Councilman Miller. Mr. Morales, if you'll please stay. Mr. Councilman Gallagher has a question, if there's any other comments, and then Council President Brady.
Following Mr. Miller and listening, I think, to what you said, 2.03, do we have a problem in there? Where's our authority? Is it the budget? Is that our black line?
That's not the limit of your authority, no, sir. The budget is
As far as dollars expended.
The budget is the proper is the generally accepted way in which the legislative authority is exercised over dollars. Yes, the approval of the budget.
So we approve the budget. Anything outside the four corners of that budget is outside the letter of the law.
I'm not sure I understand your question.
If we approve $4 for you for a full year and you spend $5 without coming back and asking us, you are $1 outside the budget. Where's the law at? Where is it legal and where is it illegal? Where is it right? Where is it wrong? And I think that's what we need to get to. Where's our authority here?
I don't disagree with you. I agree completely with you that when council passes a budget, it needs to be adhered to.
But 2.03 provides for the executive what?
For administrative authority, but the
That's pretty broad.
But there's no disagreement that the exercise of administrative authority must be within the budget as passed by council. Clearly.
Are we within the budget passed by council?
That is my understanding, that all funds that were expended to pay these, I think it's $600,000 in 2014, 15, and 16, for a total of approximately 1.75, something like that, that they were within the budget. Now, I don't know if during the budget hearings there was an explicit discussion regarding payment going or additional compensation being paid to.
Well, I can tell you there weren't. The only ones that talk about overtime, quite honestly, is over at the jail, openly, because we have a problem with that, and it's necessary. But it seems to me that not only we're dealing with 1.03, I think now we're dealing with 2.03.
And 6.05 of the manual.
Okay, thank you.
Brady?
Chairperson, Mr. Morales, you had indicated that you were speaking for HR.
Yes, sir.
Is it your impression that you are aligned with the position of the law department on these issues?
I apologize. I have not. I've not had a discussion with the director of law in which he has said to me, "Yes, Ed, I agree with everything you're saying." So I can't say that.
You're not strictly speaking for the administration
I'm speaking for the Department of Human Resources. Now, I do believe that Mr. Triazzi, the law director, would agree, but I am having a difficulty saying to you at this moment that everything I've said aligns with what he believes.
All right, thank you. I just wanted to ask, and if at this time our staff needs to or wants to at this time to respond to anything that Mr. Morales has said through the chair, or not.
I think that's appropriate, and I'd like to welcome you to come up. But I do, if I heard you correctly, you cited 2 new things that we had not yet heard. Can you reference them one more time?
Yes, Madam Chairman. Section 6.05 of the Policies and Procedures Manual is the reference that I made. Then I also made reference to various charter sections.
And 32517 of the Ohio Revised Code?
Yes.
And 2.03 of the charter was also cited, is that correct?
I did cite 2.03 of the charter.
Okay.
Yes, Madam Chair.
I'm just finding this to be new information, and we were only focusing on 1.03, so this is all relatively new, given the circumstances, and it's not a new circumstance, but these are certainly new things that have been brought to our attention. So I'll turn it over to Mr. Mackler. Thank you.
Thank you, Madam Chair. That's actually why I was going to come up. I just wanted to say as I mentioned earlier in the timeline, over the past year, the Audit Committee, the Department of Internal Audit, I think was doing an amazing job working with the Department of Human Resources on addressing the findings in the Audit Committee. And as in every audit that the Internal Audit Department conducts, there is a management response to every finding. And over the past year, not once in any of those findings were any of these sections referenced in any of the findings. So when I hear these new sections as an audit committee member, it's a little surprising because that's not what was related to the audit committee and not even addressed in the final version of the audit. So they are new sections, but Madam Chair, you beat me to the punch to bring that up. If I could respond to Councilman Gallagher's question about the budget authority, the way the budget is created by the Office of Budget Management, there is not a specific budget line for extra pay for these employees. Really, there is overtime pay, as you referenced, for like juvenile court, the sheriff's office, and other areas where overtime is allowed. The budget flexibility, I guess, that would prohibit the budget authority to be within the existing department's budget would only be because of vacancies. There's not a specific budget line that would allow for this additional pay that goes above the 40 hours worked. So to answer your question, there's not a specific line within the budget that would allow for this type of pay. It's available in there because of vacancies, but it's not a specific budget line.
Thank you, and I also want to reiterate their point that this was not quote-unquote overtime, but additional pay, if you will, as defined by the Ohio Revised Code that was also cited today. So are there any other questions, comments, or concerns from the committee? Yes, we will hold this item till we receive the requested documentation for further discussion. Thank you very much. If there are no other matters that hold our attention and no public comment related to the agenda, then this meeting is adjourned. Thank you so much.